My name is Suzette Malveaux. I'm the director of the Byron White Center for the Study of American Constitutional Law here at the University of Colorado Law School. And I want to welcome you to the last speaker of our speaker series this year. We're really excited to bring to you Professor Morgan, who is going to be speaking about a critical topic and a really important intersection between critical race theory and disability law. Today, we are co-sponsoring this event with BALSA, the Black Law Students Association of University of Colorado Law School. Let me just start by thanking everybody before we jump into the programming. First of all, I want to thank Professor Doug Spencer, our distinguished faculty fellow who has been with us the entire year and has done a wonderful job in terms of organizing the speaker series. I want to thank Melissa Schenter and Kelly Ilsing, again, who have been working really hard in the background, organizing events like this. And of course, our IT folks who are making this happen. I want to thank our student fellows this year, Leonard Pollard, Neil Sandhu, and Lindsay Floyd. And Lindsay is actually going to be moderating for us today. He's going to be introducing our speaker as well as facilitating the Q&A. And then, of course, I want to thank Jamelia Morgan, Professor Morgan at University of Connecticut, who will soon be at UC Irvine. Congrats. Who is going to be sharing her groundbreaking work in terms of the intersection of two areas of law, critical race theory and disability law, otherwise known as Discrete. And before we jump in, let me take this moment to acknowledge that we are meeting on the lands of the Cheyenne, Arapaho, and Ute nations, and just take this moment to pay respect to the elders, past, present, and future, who lead these communities. So today, I'm excited to have with us an expert in really two important fields or two areas of law, which I have mentioned, Discrete. This is a really timely topic. As we have seen the health disparities among people of color during COVID, it's really brought to surface in stark terms the inequalities in our country, the vulnerabilities based on race when it comes to access to healthcare, clean drinking water, and environmental justice issues. So there are a number of overlapping issues between race and public health and the rights of those with disabilities. So today, Professor Morgan offers a theoretical framework that moves us from understanding from the individual really to the systemic, really pushes us to go beyond the silos that we are familiar with. So I'm really grateful. I thank you so much, Professor Morgan, for being here. I'm now going to turn the program over to Lindsay. We are in excellent hands. Lindsay is going to go ahead and give you further background information on Professor Morgan and is going to facilitate the Q&A. So at this point in time, Lindsay, will you take it from here?
I'd like to introduce you all to our speaker for today. Jamelia Morgan is a law professor at the University of Connecticut School of Law. Her teaching and current scholarship focuses on issues at the intersections of race, gender, disability, and criminal law and punishment. Her research examines the development of disability as a legal category in American law, disability in policing, overcriminalization and the regulation of physical and social disorder, and the constitutional dimensions of the criminalization of status. Prior to joining UConn, Ms. Morgan was a civil rights litigator at the Abolitionist Law Center, where she worked to improve prison conditions and end the use of solitary confinement in Pennsylvania state prisons. Prior to that, Professor Morgan was an Arthur Lyman Fellow with the ACLU National Prison Project. Professor Morgan's work has always focused on the impact of the carceral state on individuals with disabilities, and she even authored an ACLU report titled Caged In: Solitary Confinement's Devastating Harm on Prisoners with Disabilities. Professor Morgan is a 2013 graduate of Yale Law School, where she interned at the ACLU of Mississippi, the NAACP Legal Defense and Educational Fund, and Emory Selly Brinkerhoff and Abadi. Prior to law school, she served as an associate director of the African American Policy Forum. Please help me welcome Professor Morgan.
Thank you so much, Lindsay. Thank you, Professor Malveaux and Professor Spencer, for the invitation to discuss my work with you all. Thank you to all of the attendees. I know it's a particularly difficult week for those of you in Boulder, sending light and love your way. And thank you again for the opportunity to talk to you all about my research. I'm going to share my screen with you. What I'd like to do is spend somewhere around 25 to 30 minutes talking about what I term a discrete approach to American law. I then would really appreciate feedback and questions as to some of the ideas that I present in my remarks. This is definitely a provisional work in progress, a lot of big ideas, and I could really use the feedback, but I hope at least that there will be some bits of information that you can take and apply to your work. So it's been over 30 years since Congress passed the Americans with Disabilities Act. In passing the ADA, Congress expressed a firm commitment to, quote, provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. As many disability rights activists and scholars have documented, the passage of the ADA could not have happened without the determination, organizing, and mobilization of members of the disability rights movements. Yet, and as disability law scholars have long recognized, though there have been tremendous gains made in the movement for civil rights for disabled people, the passage of the ADA has not led to dramatic improvements in many of the material conditions affecting a substantial portion of disabled folks. The nationwide affordable and accessible housing crisis has rendered many disabled people without shelter, leaving them to engage in life-sustaining activities in public spaces that are heavily policed. Cities and localities continue to pursue aggressive policing strategies, including broken windows or quote unquote quality of life policing that target low-income unsheltered disabled people in public space. Along with aggressive policing strategies, systematic divestments from community mental health care and social benefit programs have created conditions fertile for over-policing and over-criminalization, which have in turn contributed to high rates of disability in local jails, state and federal prisons. Though certainly the Affordable Care Act has led to significant progress in providing disabled people with access to affordable health care, they continue to face discrimination in healthcare coverage and services. Most recently, the ongoing COVID crisis has revealed yet another example of just how vulnerable disabled people are to death and disease, whether held in nursing homes or group homes, or living in states that early on adopted rationing systems that identified disabled people as low priority for certain life-saving treatments and therapies. For whatever gains have been made, it is clear to see that the goals of equal access, meaningful social inclusion, autonomy, and freedom from discrimination have not yet been fully achieved. Under inclusive approaches to disability law, policies and practices that lack an intersectional lens will fail to appreciate the full scope of harms, from healthcare discrimination to institutionalization to policing, that affect disabled people, and particularly multiply marginalized disabled people of color. What I want to discuss in my remarks today is how a discrete approach to American law builds onto existing critical race theory and disability law frameworks to both deepen our analysis of the social harms that affect disabled people and illuminate pathways to more robust legal protections. Founded by education scholars Dr. Subani Anima, Dr. David Connor, and Dr. Beth Ferry, Discrete explores the ways in which both race and disability are socially constructed and interdependent, and includes 7 tenets, which I'll discuss today. In my talk, I'll discuss the theoretical foundations of Discrete, critical race theory, and disability studies before turning to how Discrete can expand our understanding of the subordination of disabled people and what law can do to better frame legal injuries as well as protect against or reduce these social harms. This intervention could not be more timely as the existing social harms against disabled people demonstrate. Further, as scholars like Beth Rebay have noted, there is room for deeper engagement with disability in CRT scholarship, although there is certainly growing attention to the intersections of race and disability in that body of scholarship. Similarly, I build on Rebay's work and other legal scholars, including Dean Camille Nelson, Jasmine Harris, and Natalie Chin, and note that similarly, there is an opportunity for deeper engagement with issues of race and critical race theory in disability law. So let me now turn to CRT and disability studies. One of the primary contributions of critical race theory is the theoretical foundation and legal support for the notion that racism is endemic to American society. As Professor Adrienne Wing puts it, a central premise of CRT is that racism is a normal and ordinary part of our society, not an aberration. A second tenet of CRT is the notion that race is a social construction and that law constructed racial categories largely through defining and delineating the boundaries between those persons labeled as white and those racialized as non-white. In the process, laws and legal doctrine work to not only construct race, but also to uphold white supremacy, in particular by assigning advantages and disadvantages based on those racial classifications. In many leading works of CRT scholarship, they have demonstrated how law is not neutral and how it can both perpetuate, although also ameliorate, white supremacy. Disability law scholars have applied key ideas from disability studies to demonstrate that disability is in part a social construction. And for the most part, the scholarship rejects medical models of disability. In a recent essay, legal scholars Duran Dorfman and Rabia Belt document this intellectual history of disability studies and note that a social model of disability contrasts with a medical one, in that the former focuses not just on impairment, but the social meanings that attach to those impairments. In this way, the prevalence of the social model of disability in disability law scholarship affirms a commitment to understanding disability as rooted not in individual deficiencies, but social barriers, stigma, prejudices, and also ableism. Now, disability justice activists Talila Lewis and Dustin Gibson define ableism as follows: a system that places values on people's bodies and minds based on socially constructed ideas of normalcy, intelligence, excellence, and productivity. These constructed ideas are deeply rooted in anti-Blackness, eugenics, colonialism, and capitalism. This form of systemic oppression leads to people in society determining who is valuable and worthy based on a person's appearance and/or their ability to satisfactorily reproduce, excel, and behave. As the quote suggests, ableism is rooted in and reinforced by white supremacy and informs how we think about meanings of disability, and in particular disability as it manifests in people of color. As Discrete founders Anima, Connor, and Ferry write, disability and race bear an important relationship because disability as a social construction is informed by race. Further, racism and ableism are mutually reinforcing. They explain that racism and ableism are normalizing processes that are interconnected and collusive. Racism validates and reinforces ableism, and ableism validates and reinforces racism. In fact, racism and ableism are so enmeshed in the fabric of our society and social order, they appear both normal and natural. As the foregoing suggests, Discrete provides an important analytical tool to examine racism and ableism as mutually reinforcing processes of social subordination, marginalization, and violence. It also helps us understand how race informs social meanings and ways of thinking about disability, and how disability in turn informs meanings and ways of thinking about race, as well as the unique vulnerabilities that multiply marginalized disabled people of color experience. So in the next part of my remarks, I want to discuss the key tenets of Discrete and offer a template for what Professor Kim Crenshaw termed over 30 years ago, intersectionality. So as I noted, this is a project that's both exploratory and a call for subsequent engagements. It offers, I think, opportunities for future critical projects that will engage with both race and disability, along with, of course, gender, class, indigeneity, and other identities and statuses across various sites of American law. So let's get started. So Discrete's first tenet focuses on the interdependent ways that racism and ableism shape notions of normalcy. As stated, Discrete offers a lens from which to examine the ways in which racism and ableism are mutually constitutive processes. As we know, racial ideology provided justifications for the legally sanctioned enslavement of Black people and the violent dispossession of Indigenous people from their lands. I will discuss both in turn. We know racist ideologies justified the enslavement of Black people, but ableism also played a role as well. Disabilities, whether in the form of physical attributes or conditions labeled as quote unquote illnesses or quote unquote defects, discounted the value of Black bodies. Disabilities also formed the basis for disputes involving alleged breaches of warranty, where the buyer and slaver alleged, for example, that the enslaved Black person was quote unquote defective due to disabilities and therefore unable to work, or that the buyer and enslaver alleged that due to the disability, the enslaved person was prone to running away, a medical term at the time labeled as drapetomania. These cases demonstrate that in the midst of chattel slavery, social meanings related to disability were formed, including forms of resistance by enslaved Black people through claiming or feigning disability, as scholars like Dia Boster have argued. Furthermore, scholars have shown how courts, through judicial opinions in the early years of the American Republic, created and assigned property rights to whites in so-called uninhabited lands, while refusing to recognize the property interests in lands held by Native Americans. Scholars of settler colonialism have acknowledged the role of race and its function as part of a broader scheme to violently dispossess Native Americans of land and to fuel the rapid and violent expansion of white settlers westward. As Professor Kelly Lytle Hernandez explains, settler societies strive to block, erase, or remove racialized outsiders from their claimed territory. Though not typically discussed, ableism also justified this massive dispossession and displacement. More specifically, ableist tropes of indigenous people as quote unquote lazy or quote unquote ignorant serve to justify violent dispossession and displacement. As historian and scholar Evelyn Nakano Glenn argues, white settler property interests structured racial and gender classifications and characterizations of indigenous peoples. As Glenn argues, masculine whiteness became central to settler identity as status closely tied to the ownership of property and political sovereignty. In the view of white settlers, the fact that, and I'm quoting here, the fact that Indian women did heavy physical labor and were ignorant of modern housekeeping methods accounted for Indian men's laziness and disinterest in material progress, end quote. Although it may not at first glance appear as a reference to ableism, the construction of Native American men as lazy is an ableist trope. To designate a body as lazy is to make a judgment as to the perceptions of productivity that can be traced to particular ableist meanings of disability, which are in turn linked to stereotypes of physical and moral deficiency. Discrete Tenet 2 acknowledges multidimensional identities instead of singular notions of identity such as race, disability, social class, or gender. This tenet emphasizes the importance of intersectional approaches that include disability as a relevant category of analysis in order to prevent marginalization of disability from legal issues. For example, activist and scholar Kat Perez applies CRT in disability studies to examine immigration law and policy in order to shed light on the experiences of disabled people of color and to center these lived experiences in the immigration law reform debate. As Perez writes, her work aims to, quote, present the work of the National Coalition for Latinx Folks with Disabilities as an exemplar of how grassroots disability justice movements are complicating our understanding of disability and prescribing more complex solutions to the immigration debate. As Perez cautions, progressive immigration reform can only take place when we consider the unique ways in which racism and ableism interact to permeate our immigration system. Discrete Tenet 3 rejects the understanding of both race and disability as primarily biological facts and recognizes the social construction of both as society's response to differences from the norm. So as I noted, critical race scholars acknowledge race as a social construction, and disability law scholars by and large define disability as consistent with a social model or social theory of disability. However, in legal scholarship, there is little engagement with how both disability and race were socially constructed in tandem and how these mutually constitutive meanings contribute to the subordination of disabled people today. The lack of engagement in legal doctrine with these co-constructed social meanings of race and disability contributes to, I argue, the failure to adequately protect disabled people of color who are policed, imprisoned, undocumented, unsheltered, and struggling in conditions of poverty. To illustrate, I'll provide two examples from Crim Pro and and constitutional law. First, disability as an identity, as I argue in a future forthcoming paper, is not given sufficient attention in Fourth Amendment doctrine, leaving disabled people vulnerable to stops, frisks, arrest, and even detention for disability-related behaviors. As I discussed in the paper, Disabilities Fourth Amendment doctrine fails to adequately protect the constitutional rights of disabled people, and in so doing reinforces a normative body mind entitled to those protections. In this way, it renders vulnerable to police surveillance, suspicion, searches, and force those persons whose physical and physiological conditions, abilities, appearances, behaviors, and responses do not conform to the dominant norm. By focusing in on how Fourth Amendment doctrine both erases disability and fails to adequately protect disabled people's privacy and security interests, I suggest how the doctrine itself renders them more vulnerable to policing and police violence. Second, as I argue in another paper, Policing Marginality in Public Space, weak constitutional protections against the criminalization of status under the Eighth Amendment can render disabled people, particularly those who are low or no income, people of color, vulnerable to criminal sanction, even on account of their disabilities. Ongoing litigation around constitutional protections against the criminalization of status, see, for example, Boise versus Martin, show federal courts divided on whether conduct inextricably linked to status may be criminalized. This means that conduct from public intoxication to disorderly conduct, in some cases, conduct actually linked to disability, don't count as unconstitutional status-based crimes. Thus, the Eighth Amendment offers, in those cases, no protection against punishment for such conduct. Given that the Eighth Amendment jurisprudence also doesn't pay sufficient attention to race and, unsurprisingly, disability, disabled people of color are here again rendered vulnerable to aggressive policing and punishment without adequate legal recourse. Tenet 4 of Discrete is to disrupt the tradition of ignoring voices of traditionally marginalized groups. This notion of voice is discussed in CRT, the notion of outsider jurisprudence, what Mari Matsuda, who coined the term, defines as jurisprudence derived from considering stories from the bottom, is put forth in Discrete as a way to disrupt master narratives and produce counter narratives in law. Tenet 4 offers an important intervention because legal doctrine and the legal profession continue to struggle to center the voices of disabled people in doctrine, as well as understanding of disability and responses to disability. Rather, legal doctrine tends to contain depictions of disability that are rooted in a medical model of disability or reflect pity or paternalism, and by doing so, work to reinforce associations between disability and dependence or deviance. For example, in prior work, I've argued that the Eighth Amendment conditions of confinement jurisprudence may require advocates to reinforce medicalized notions of disability that center the violence and harms stemming from imprisonment in the bodies and minds of disabled incarcerated people, rather than in the systems and structures that may contribute to their disablement. This leads to pleadings, briefs, and legal opinions that reify constructions of disability, particularly psychiatric disability, as invariably pathological, tormented, uncontrollable, violent, and deviant. Discrete Tenet 5 considers legal, ideological, and historical aspects of disability and race, and how both have been used separately and together to deny the rights of certain citizens. During the eugenics period, when racist pseudoscience was propagated to justify the superiority of the so-called white race, the predominant notion of disability was that disability distorted the ideal white body mind. That is because under the racist logics of eugenics, disability corrupted the purity of the white race. As the argument it did so by introducing mental and physical defects that detracted from eugenicists' conceptions of whiteness as physically fit, intelligent, industrious, and moral. By contrast, negatively racialized groups were positioned as lacking in those desirable and inheritable traits under the common eugenicist conceptions. racist conceptions of Black people as unintelligent, criminal or infantile, Native Americans as lazy or infantile, Chinese people as vectors of disease, to name some of the racist conceptions of the time, work to construct and reify racial categories and stereotypes through physical and mental attributes that distinguish white from non-white and subjected so-called racial others. Though historically these conceptions have long existed and continue to exist to dehumanize racial others, the period of eugenics represents a dramatic expansion of state power to regulate white bodies, to prevent reproduction or to incapacitate them in state institutions, and to prevent the racial mixing that was regarded as a threat to white racial purity. Forced sterilizations, the birth of state mental hospitals, and the proliferation of anti-miscegenation laws demonstrate a coordinated set of state policies designed to whiten the increasingly racially and ethnic diverse American society. In Buck versus Bell, the Supreme Court decided that the forcible sterilization of Carrie Buck did not deprive her of the right to equal protection and due process under the 14th Amendment. As you may know, Carrie Buck was a 17-year-old, and when she, at the time, she was labeled by the state of Virginia as quote unquote feeble-minded and sent to the state colony for epileptics and feeble-minded persons. In 1924, the colony's superintendent, Dr. Albert Priddy, selected Buck as the first person to be sterilized pursuant to Virginia laws, pursuant to Virginia law passed that same year. The law professed that the health of the patient and the welfare of society, and I'm quoting, may be promoted in certain cases by the sterilization of mental defectives. Virginia justified such invasive and drastic action as necessary to protect society from would-be quote unquote menaces who, if released, would procreate and transmit such undesirable traits like insanity and imbecility. The eugenics period also marks the height of state-sponsored efforts to locate social problems within racialized bodies and minds, labeled as defective, ill, insane, disordered, and feeble, to use the language of the time. Once social problems became linked to those bodies and minds, these groups could be more readily managed and controlled pursuant to the state's police powers. Once linked with immorality, criminality, and promiscuity, such traits supported by pseudo-scientific evidence formed legal bases and justification for institutionalization. Once institutionalized, women so labeled were then forcibly sterilized on the grounds that the state had an interest in preventing women from reproducing with these so-called undesirable traits. As Professor Kiara Bridges has argued, some whites with disabilities were viewed as, quote, not quite white, what Bridges describes as a corrupted whiteness that has yielded them a reduced racial privilege. Bridges's intersectional analysis of the sterilization of Carrie Buck demonstrates how Buck's white privilege, along with the label of having a cognitive disability, rendered Buck vulnerable to sterilization. As I've tried to suggest, a discrete approach offers an explanation for why forced sterilization as a practice fell within the ambit of state power. Stated differently, this lens provides theoretical grounding for examining the pervasiveness of forms of state control over the reproductive capacities of women, and in particular low-income Black, Latinx, and Indigenous women. By constructing Black, Latinx, and Indigenous women as lazy, pathological, and incompetent, state entities could more readily construct legal justifications for laws, policies, and practices that deprive these women of their reproductive rights, parental rights, and criminalize them when they're held in conditions of poverty. Thus, a discrete approach provides a way to center race, gender, and disability in ongoing issues relating to reproductive justice, poverty, and parental rights. Discrete Tenet 6 draws from the groundbreaking work of Professor Cheryl Harris and her article, Whiteness as Property, to recognize that whiteness and ability function as property conferring economic benefits to those who can claim whiteness and or normalcy, and disadvantages to those who cannot lay claim to these identity statuses. To explain how this tenet may apply to law, I'll discuss how racialized notions of disability influence early immigration laws. In the late 19th and early 20th century, as the number of immigrants increased, scientific racists aligned themselves with other nativist interest groups to provide biological arguments in support of immigration restrictions. During this period, immigration laws reflected the clear objective of keeping disabled people, termed at the time as defectives, out of the country. Indeed, the Immigration Act of 1917 provided that it shall be unlawful to bring any to bring to any port of the United States any alien afflicted with any mental defect or physical defect of a nature which may affect his ability to earn a living. The list of those excluded was long. The deaf, blind, those labeled as epileptic, people with curved spines, hernias, flat or clubbed feet, missing limbs, people with intellectual and psychiatric disabilities, men of quote unquote poor physique, and men diagnosed with quote unquote feminism. Later on, in statements in support of the Immigration Restriction Act of 1924, one representative leading efforts to pass the bill noted, it has become necessary that the United States cease to become an asylum, not only were disabled individuals excluded, but particular racial and ethnic groups were also identified as having undesirable traits based on their susceptibility to mental, moral, and physical defects. As historian Douglas Banton notes, the desire to keep out immigrants deemed defective was not an isolated development, but rather was one aspect of a trend towards increasing segregation of disabled people into institutions and the sterilization of the quote unquote unfit and degenerate under state eugenics laws. Such engagement with whiteness and ability as property could add a necessary layer to ongoing critiques in immigration law. Finally, Discrete Tenet 7, which affirms Discrete support for activism and diverse forms of resistance. Discrete stands alongside movement-based activism led by and for disabled people, including movements like disability justice. A disability justice approach, and I'm drawing from Patty Byrne and the group Sins Invalid, recognizes that, quote, able body supremacy has been formed in relation to intersecting systems of domination and exploitation, and that it is impossible to comprehend ableism without grasping its interrelations with heteropatriarchy, white supremacy, colonialism, and capitalism, with each system co-creating an ideal body mind built upon exclusion and elimination of the subjugated other. Central to disability justice frameworks is the notion that all bodies are unique and essential, and that all bodies have strengths and needs that must be met. A discrete intervention into American law can explain why over 30 years after the passage of the ADA, disabled people remain a subordinated group within society and are often erased or marginalized across areas of law. As both CRT and disability law scholars have long argued, there are clear limits to formal equality. Adopting a discrete approach to American law offers a lens through which to both identify the potential limits of legal rights and remedies, and how to develop more robust legal and policy arguments in support of broader legal protections and greater legal remedies for disabled people. The seeds of such analysis have been sown in legal scholarship, as I've attempted to demonstrate, but more robust engagement and analysis are needed. I hope I provided some possible engagements and sites for further inquiry and to spur additional expansions of this robust theoretical framework into additional areas of American law and policy. Thank you all for taking the time to listen.
We will now be taking a Q&A portion. So if you are in the audience and you have a question, please use our Q&A function, and I will ask Professor Morgan all of your questions.
Mm-hmm.
Professor Morgan, I do have a question for you. Someone asked, how would you deconstruct the ADA and the Civil Rights Act of 1964 as amended and reconstruct them consistent with Discrete?
I'll speak to the ADA since I've spent much more time thinking closely about that statute. I think that the ADA is a very robust statute. It has a definition of disability that I believe, and other scholars agree, is more aligned with the social model of disability, which is to say that the statute recognizes that some of the discrimination that disabled people experience is not the result of intentional, purposeful discrimination, but perhaps what we could term, or what the statute legislative history terms, sort of benign neglect, right? The failure to adequately consider disability in constructing buildings, designing legal education programs, designing workplaces and job opportunities, for instance. So I think the seeds are there. In my work in policing, I've identified that courts have a narrow view of disability, a view that's aligned with the medical model when they're looking at things like policing and the protections that the ADA arguably provides for disabled people who are wrongfully arrested, or disabled people who are entitled to accommodations but are not accommodated in interactions with law enforcement. They adopt a medical model, and that model limits the possibilities for relief for plaintiffs, and also doesn't accurately, I believe, identify the type of discrimination that's at issue when we think about the policing of disabled people. So the fact that we use criminal law and we use policing, the enforcement of criminal law, to regulate what are deemed disruptive or disorderly people, often people with disabilities. Sometimes we can see that as labeled as people in mental crisis. We use that apparatus to regulate that type of non-normativity, as opposed to providing in-community supports and care. That becomes a site for disability discrimination. And I think that the ADA has something to say about it, but if courts have a cabin view of how disability discrimination looks today, they won't apply the ADA as expansively as they can. So certainly possibilities under the ADA. And in prior work, I've looked at reasonable accommodations under the ADA in the employment context. So again, to kind of think about what those analogs would be under Title VII in an employment discrimination law context. But what was interesting is that under the ADA, at least for Title I cases, there were a number of cases that identified reasonable accommodations as a type of preferential treatment or affirmative action, which I thought was really interesting, considering that language isn't appearing anywhere in the ADA. But it really kind of hearkened to the ways in which the affirmative action debate across sectors, across areas of law, have influenced the ways that courts think about disability accommodation. And so I know, learn law in silos, practice law in silos, but these ways of thinking about disability and the wrong ways of thinking about access and inclusion pervade other areas of law beyond just disability law, which is why I tried to have this broad focus on American law.
Okay, another question for you is, how has the study of intersectionalism comported with what we've seen evolve with COVID-19? Has COVID affected what we've seen in terms of the way in which intersectionalism is studied?
Yeah, so I'll term it intersectionality, just because I sometimes can be very jargony. So I think in thinking about the current pandemic, there certainly has been a recognition of disability in movement spaces, which I think suggests that there is greater attention to intersectionality in advocacy around issues relating to policing and healthcare and access to healthcare discrimination, et cetera. So a couple of examples. So, I mean, it's been a little bit over a year, but if we can think back to the start of the pandemic, there was a number of jurisdictions that had turned to quality of life policing to regulate public spaces and to penalize individuals that were in public spaces after shutdowns, were not enforcing or were not complying with mask mandates and things of that nature. And so there was a number of groups that identified this as a problem that would render vulnerable unsheltered communities, people of color, communities that find themselves in the crosshairs of over-policing in any event. And so early on, groups like Insight, groups that identified as abolitionist centered, in a way that I think is consistent with intersectional practice, these issues as relates to, the pandemic and also criminalization. I also will name disability rights organizations, mainstream organizations, and disability justice activists also made sure to highlight very early on the particular dangers in so-called group homes and adult homes and nursing homes. And what's interesting to think, about these histories and these genealogies that I've just documented is that as we see, these congregate facilities have become vectors for disease and spreading the virus. These arguments were made well before COVID, that these congregate facilities are carceral, not just like prisons and jails, but similar to them. And you can think about the Olmstead litigation and that the watershed case that identified unjustified isolation as a basis for discrimination under the ADA as being consistent with some of these calls, the independent living movement to point to disability rights movements. So that was centered early on. And of course, in that advocacy, not only raising that as a disability rights issue, but as a racial justice issue. And also, I think in many ways centering class in the analysis. And so I think, I guess, looking back, I have seen intersectional advocacy around the COVID issue, particularly as Professor Malveaux mentioned early on, the racial disparities in who contracts the disease and who is dying from the disease, and the disparities and disproportionate impact on communities of color and Black people and Latinx people and Indigenous people. And so I think that has definitely been centered, and disability rights movement and those that have identified the disability issue in this current moment have also brought that to the fore.
Another question regarding COVID. Someone asked, this is kind of long, so I'll read it to you. A common refrain among people advocating against COVID restrictions was that the virus's mortality rate is exceptionally high among people with disabilities and lower among people without. Do you think that the prevalence of arguments with such extreme disregard for lives along the lines of ability will cause more widespread attention to disability rights in the future?
I'm sorry, you cut out for a second. I'm really sorry, Lindsay. Do you mind repeating the question for me?
Yeah, a common refrain among people advocating against COVID restrictions was that the virus's mortality rate is exceptionally high among people with disabilities and lower among people without disabilities. Do you think that the prevalence of these types of arguments will cause more widespread attention to disability rights in the near future?
Well, I think the current discussion more so about what's been happening in nursing homes and congregate adult facilities will do more, I think, to raise attention to the issues and the plights of those that are held there. And I think one of the things that you can think about is that this is, and as well, I will also center prisons and jails, right? Because I think for the first time, we're not really for the first time, but like it's kind of the confluence of a number of factors. Discussions around abolition, the pandemic have really centered in prisons as, again, vectors of disease, sites of harm, just due to the fact of the literal physical plant and the conditions of incarceration. And so when I hear a focus and an attention to the disabled folks that are in nursing homes and group homes, or even, an elderly or aging population, I think that I see opportunities to have these broader questions of political economy, like what are responses after this moment, after this dramatically devastating pandemic. I would hope there would be opportunities for conversations around political investments in community-based care, right? In supportive housing arrangements, in supporting people as they transition out of facilities, whether we're talking nursing home, group homes, prisons, or jails, to ensure that they have the in-community supports and treatment that they need to thrive independent of these institutions. And so there's a way in which the vulnerability to the disease has been centered in these spaces, of course, given the design of the plans. There's a way in which like the universal harms that the pandemic has rendered has made all of us aware of things that are our own mortality and vulnerabilities that we may not have been. I, as sort of a cynical person, am less optimistic of these empathy-based arguments. I think that this is about power, and I think it's about changing structures. And so it's a question of political will and mobilization. And in that sense, we can turn to communities, disability rights, disability justice, racial justice, thinking about the organizing that's happening in Indigenous communities around the country to identify their disparities to the lethal pandemic and vulnerabilities to lethal pandemic, that is, and the responses to that. And so I think that's sort of where I look in terms of maybe if there's a light of optimism following the pandemic, it comes from that, less so from, you know, thinking about vulnerabilities to the disease on the individual basis.
Thank you. Another question for you. Has the Pregnancy Discrimination Act, which also requires a reasonable accommodation at the intersection of gender and disability law, resulted in more understanding and compassion regarding the intersection of disability and race?
That's a good question. I think that that's probably a really good note topic, but I can't, I think there's a possibility there, but I can't speak to that specifically.
In your view, is there a role for thinking of intergenerational trauma and PTSD caused from slavery, Jim Crow, violent policing, and other areas of racial violence a part of the conversation on racial justice?
Sure. So I definitely see that as connected to conversations in disability studies scholarship and disability, critical disability scholarship, as well as disability justice movements that are looking at disabilities created by structural and state violence and centering that in a movement to acknowledge and claim disabilities in communities of color. So which is to say, if you acknowledge that we have communities that are disproportionately exposed to environmental toxins and pollution, policing, and the disabling and debilitating effects of policing, whether we're talking about PTSD or physical sort of harms, then we're going to have a generation of people that have disabilities that were created by these violences, right? Asthma, COPD. We can think about the various ways that they manifest. Scholars like Jasbir Puar and Nirmala Arabelis talk about these as debility, so as not to stigmatize disability, which is to say, it's like, if you can identify a structural analysis for identifying the manifestation of your disability connected to this state-based harm, then you've done the work in not only claiming a part of your identity by which you certainly can have pride. So I support disability pride movements, but it also connects now to a critique of a system that has led to this debility, which is to say that I am very much in line with disability justice movements that claim pride in their disabled identity, but that yet also acknowledge the harms, the hurt, the difficulties that come from recognizing the origins of those disabilities. It's very complicated, and I don't intend to simplify it, but especially when we think about the critique of disability movements as being predominantly white and predominantly privileged, I think there's also a way in that we have to address, like, disability as appearing and materializing in different ways and how that impacts one's ability to claim it. But there certainly are questions within these spaces about intergenerational trauma and what it means to claim disabilities and how it impacts one's current lived experience and future opportunities.
Thank you for that question or that answer. I'm going to try and pare this down a little bit, but a lot of the scholarship in Discrete incorporates critical theoretical approaches, which has created, increasingly specified terminology that may not be widely understood. Someone would like to know how this isolates communities of those with intellectual disabilities or people who just might not have access to these types of theoretical approaches, and how do we balance the need to engage them in conversations while also advocating and researching?
Yeah, that's a very good question. And as a scholar, academic, I have to be very mindful that, my account in my work is not only informed by the lived experiences of those that are proximate to forms of state violence and deprivation and discrimination, et cetera, but not like completely disconnected and hard to grasp. So there are a couple things. Like, I think there are some partnerships, if you will, or bridges that can be built. So I have, as a scholar, a role to sort of teach and inform, and frameworks for me provide a way for improving the law. I'm specifically speaking to courts, I'm specifically speaking to law professor and practitioners, et cetera. So language does matter because we're kind of trying to map a theoretical critique onto an existing set of legal regimes. But when I think about my practice as like a litigator, working as a movement lawyer, then I'm partnering with folks on the inside, so incarcerated people. And it matters to me that in representing them, I identify the harms that they're experiencing in the way that they're experiencing them. And so what that means is that sometimes what I might perceive as disability discrimination is not framed as such. And I have to give my clients the autonomy and agency to decide and to, inconsistent with sort of movement lawyering, frame the legal claims that we raise. And so I talk about this in a paper talking about ableism and prison reform litigation, that we certainly don't want to graft ways of thinking about disability onto our clients, onto the people that we're organizing in community with. We certainly, consistent with so many models, want interactive processes for understanding what accommodations are necessary, or in understanding how one perceives of disability, or what are the appropriate responses to disability. We definitely have to center movements, which is why I think, consistent with Discrete, it has to be led by those that are experiencing these particular conditions. And there's a number of self-advocacy groups out there that are talking about these issues. So I'm on the board of ARC, and there's a specific criminal justice program within ARC that is specifically addressing some of the problems that folks with IDD face in policing and prisons, and also as individuals who have experienced victimization from crime. And so there are ways in which, like, centering those that are directly impacted, that have that lived experience, can move us away from the jargon as we move to identifying actual concrete solutions, litigating legal strategies, et cetera.
I think we have time for one more question. So my last question for you is, where does LGBTQ status come into the discrete analysis?
So it definitely is centered. And I think when I think about some of the early cases that I mentioned, when you look specifically at the Immigration Act of 1917 and 1924, you see specifically LGBT communities identified as deviant, identified as providing a basis for exclusion. You can also think about the way in which the actual identity was labeled as deviant and using medicalized science. And that's the sordid history of this. There's a way in which these constructions were grafted onto groups as a way of labeling them as others. I think today in the policing work and actually work in prisons, if you think about the ways in which trans communities are often labeled and targeted by police for engaging in sex work, you see not only hyper-policing as targeting these groups, but a failure to reckon with the prevalence of PTSD and psychiatric disabilities among this group as a result of the trauma of being over-policed, the high incidences of poverty, and the general exclusion and marginalization experience. And so there's an intersection there that I think has to be centered in discussions on policing. I try to do that in my policing work. In prisons, it plays out again in very tense ways, because in some cases, to get access to hormone treatments and therapies and gender affirming surgeries in prisons, one has to identify as having a disability, which for some, again, raises the issue of whether to claim disability, what disability means for them, might not be aligned with a willingness to claim it. And there's complexities, again, to that. But in prisons, in this carceral space, that is the pathway to a legal claim that can then be used to receive these treatments in a carceral space. And so lots, I think, to unpack, and I think accurate discrete analysis would incorporate LGBTQ issues as well. Again, in my work in sort of prisons and policing, I've tried to do that as well, but also looking to history to see how these pathologies, this construction of the other includes also the labeling of certain individuals as deviant among racial, gender, and gender expression fronts.
Well, thank you so much, Professor Morgan, for joining us for our last Constitutional Law Speaker Series event. It's been illuminating and wonderful to listen to your research. Up next, the Byron White Center will be hosting the Roth-Gerber Conference on Immigration and Citizenship. The conference will occur in just a few weeks on April 8th and 9th. If you're interested in registering, you can jump on our website at cu.law/Roth-Gerber 2021 or visit Byron White Center's main page more generally. But thank you again, Professor Morgan, for this, and I hope that everyone enjoyed their experience.
Thank you, Lindsay.